lovely to welcome you all here webinar about court of protection, some updates, quirks following COVID, and just a general catch up on where we are with things at the moment, and affairs and health and welfare. So we're joined today by David Gardner and Keri Tayler of No5 Chambers, both very experienced barristers in this field, and they have a wealth of experience on these topics that we're going to, so we're really grateful to be joined by them. I'm here on behalf of Bristol, and I'm a solicitor at Roy's with the solicitors. We are also hoping to be joined later by District Judge O'Neill, but I know she has a very busy diary at the moment, so we'll have to see if she's able to join us slightly later on. So without further ado, I'd like to introduce you to David, who's going to be speaking first, and then Keri. I've just also got a message from District Judge O'Neill, who is here. So I'm hoping that Claire will be able to add her to the list of panelists, and we'll be able to introduce her shortly as well. So David, if you'd like to go first and introduce yourself and what you'll be talking about today.
Hello, and thank you very much to Bristol Law Society for having me. And Keri from No5 Chambers. Yes, we're both court of protection barristers. I won't go into Keri's background. I'll just very briefly deal with mine. As I say, I'm based here in Bristol. I actually live in Keynsham, so just outside of Bristol. So I am a local, and my practice, as I say, largely court of protection and judicial review as well. So I spend most of my time in either the court of protection or in the admin court, and I deal in the court of protection with both health and welfare matters and property and affairs matters. I'm conscious of the amount of time we've got, so I'm going to go and just crack on with the presentation. I'm going to deal with two specific elements that have arisen recently in the court of protection, relating to COVID vaccinations and deputyships. I tried to come up with a snappy link that would bring the two together, but I couldn't think of one, so it's just the two elements, I'm afraid. I do have some slides to share with you, and I will just do that now, if I may. So there we go. So I'm going to start, if I may, with some of the recent case law on COVID-19 vaccinations. I think when this all started, doesn't it seem like so long ago, but when this all started, I think there was a lot of questions in the air about how these matters were going to be dealt with. We've had a few cases now, which, to my mind, in any event, really clarifies where we need to be going. These are those cases, or the main ones you will need to know about if you're dealing with a matter where P either has refused, or there are some issues relating to whether they should have a vaccination, or indeed a family member, as has happened in many of them, objects to vaccination of P. E, SD and SS, to my mind, are the big ones you need to know about, but CR is in there as well for a little bit of extra information. What we found from the case of E certainly is it started off with really an analysis of what needs to be done in terms of capacity evidence. And one of the things I think that really came through from that is that Hayden J, who gave the judgment, suggested that actually this isn't going to be a particularly complex or sophisticated process. It's quite a simple decision in reality as to whether somebody wishes to have the vaccine, or I should say has capacity to decide whether to have the vaccine. And often it's going to be simply a matter of experienced GPs or care staff dealing with it. I think that's a plea in effect from a High Court judge not to go seeking Section 49 reports routinely on these types of cases. In that particular case, a Dr. Wade, the GP, who conducted a very brief assessment, and it didn't include a huge questions asking whether P could identify the dangerous sickness and what she actually remembered and knew about it. And as a result of that very kind of overview almost assessment, the Dr. Wade, the GP, concluded that it capacity to make such decisions. I should say in E, it was cases, it's a diagnosis of dementia, and it's somebody in a care home. And on analysing that assessment, Hayden J was quite satisfied that despite it was in an informal assessment that didn't really go into a lot of detail, it was, to his mind, a sufficiently rigorous assessment to comply with the principles of the Mental Capacity Act. And I've set out the entire paragraph there. I should say there's a lot of slides to come. They're really there hopefully so that you can look at them later rather than me going through the detail of all of them. I'm really going to try and hit the headlines. But as you can see there, Hayden J really giving the steer on saying that it's not going to be huge amounts of time spent on these assessments, and these overviews will be sufficiently rigorous. Indeed, you can see that when you're looking at what information you would have to understand and retain, use, weigh, not much. And you can imagine that it was never going to be much, but we now have that high of those principles. So as you would think, it's being able to consider the likely side effects and risks. A key one, of course, disadvantages of not having the vaccination. And we all know that the risks can be great, especially to persons in those environments. And indeed, one of the suggested at the end there is in the number of injections that are going to be required. So it's not a huge deal of information that P is going to need to be able to understand or use and weigh. Hayden also dealt with best interests in the judgment as well. As you can imagine, he relied upon Section 4, as the court is required to do, and in particular started off by looking at the wishes and feelings of P, and indeed those being past and present. And indeed, as you'd expect, beliefs, values, and any other factors she could take into account. Now, one of the points that Hayden looked to in that case was the fact that she had received the flu vaccine in the past before it came along, and she was considered by Mr. Justice Hayden to be quite trusting of health professionals. And so in Hayden J's consideration suggested that actually that pushed towards the idea of it being in her best interests. Her assessment was central to what was in her best interests, and indeed those two factors suggests a positive step towards it being in her best interest to have the vaccination. Also applying Section 4, in this case Section 4.7, were going to be the views of family members. So in this particular case, it was the vaccine being given to his mother, and whilst the court noted that he was deeply sceptical about the efficacy of the vaccine, the court did, whilst taking that into account, note that it really strikes as something of a facet of his temperament and personality rather than that of his mother's. So again, it's about going back to this to P being central. And so while a relevant consideration, it's obviously P's wishes and feelings that are going to be more important. As noted earlier, in terms of capacity, clearly in terms of best interest, the risk to E is going to be a really key factor when you're determining whether it's in somebody's best interest to have a COVID-19 vaccination. And indeed, in this particular case, as you can see in a lot of cases with persons in dementia in care homes, the risks were considerably high. She was an elderly lady we know care homes, and we've seen the news suddenly going some time back, that there were often cases where COVID-19 was running rampant through care homes. So the risks to her were particularly high, and that being in favour of having the vaccine as well. And by virtue of her vulnerabilities and her background, it was Hayden J's determination that it was, without hesitation, he puts, in her best interest to have the vaccine. Hayden J also gave judgment in the case of SD. A lot of that judgment was worth reading if dealing with one of these cases. Repeats a lot of what was said in E, but there's an interesting additional element, I think, that I seek to highlight here. And in this particular case, again, it was P's daughter who was against vaccination, and she suggested a different type of treatment, an antiparasitic drug. What Hayden was quite keen and quick to shut down, I think, was the idea that the Court of Protection is not going to be in a position where it can start arbitrating on medical controversy. So the Court of Protection is not going to go into the details of medical reports and get lots of expert witnesses and try and determine which of perhaps the interests. It's not the function of the Court of Protection to do that. What the Court of Protection will do is, in effect, rely upon public health guidelines and peer-reviewed research and come to its conclusions based upon that, rather than engaging in maybe the best or an alternative treatment. So a useful add-on. So SD backing up the points made in E, but with that extra point. And in SD, it was also noted that whilst there's always going to be a strong draw towards vaccination, and I can sure we can all understand why, just taking a step back, it's important that it's not approached as presumptive. It's not always going to be the case that it's going to be in a protected party's best interests to have a vaccination. And we'll come on to SS and an illustration of that in a moment. So the guideline being set, normally you would expect it to be a yes, it's going to be in best interests, but it's got to be approached on a case-by-case basis, looking at the objective evaluation of the best interests, but also keeping in mind the centrality of P. I'm going to, looking at my time, kind of just skip over CR, but note it is another case that you might want to be aware of. It's not a dementia care home case, so it does have a different facet to it. And in that case, His Honour Judge Butler went on to consider a number of different factors that he thought P may well have considered had he been able to do so. It's a huge list. I've got to say, I don't think I would have considered a lot of the factors that Judge Butler listed, certainly not in the detail that it comes out, but nonetheless, it's probably an important judgment to read if you're dealing with a case that is a little bit unusual, in that it's not one of our persons in a care home with dementia cases, which the vast majority of the reported judgments on this issue deal with. And so I finally turned to the case of SS, where the objection didn't come from a family member, it actually came from P themselves. And it was a notable case because it was considered that P was so against the idea of vaccination, there's likely going to be a need for restraint if it was to be given. Again, turning to the analysis as adopted in EE and SD, it was important to put before the court what would have been P's views based on her past wishes and feelings and her current wishes and feelings. And in this case, on the flip side to those other cases, it was determined that SS had consistently opposed the vaccination, whilst it was potentially based upon some delusional aspects behind that. It was important to note, and as Hayden J did, that that's her reality, and that's got to be recognised and respected. So P, in this particular case, strongly resistant to the idea of having a vaccination. And that's an important point that made there, that it's not just about about health issues, it's also a larger context. It's about her welfare in general. Particularly, I think that was pressing on the mind of the court in this, that the use of restraint was likely to be quite distressing for P. It was described by one of the carers that just a persuasion and gentle restraint wasn't going to work, and even went to the point of describing they need to be kung fu experts to be able to really manage this restraint, which carers just simply did not to be doing. And I will say that the court entirely agreed with that perspective. And so, just capping off on SS, then, it was not in P's best interests to have the vaccination based so wholly in her centrality, what her views were, but also the likely welfare issues of having to restrain her to give her such a vaccination meant that the court determined, as a different approach to E and SD, that it wasn't in P's best interests. I myself have had a case which on very similar grounds where, although the restraint suggested wasn't quite as intrusive if it was going to be used, we looked at the background to P's case, and actually it turns out that for the majority of her life she had refused vaccinations of all types, such as flu vaccinations, and was, whilst not quite as strongly objecting to the idea of it as SS, clearly we had a good picture of her past wishes and feelings. So it's always going to be, I think, one of those points that needs to be weighed up based upon the individual case, but hopefully those principles will help you in it. As a final point on the issue of COVID vaccinations, because we've got this guidance now, it's likely to be heard if these issues continue to arise, and I suspect they will for some time. It's important, I think, to highlight, if you are potentially representing P, that what you'd be expecting to happen is that the one of the public bodies really should be referring this to the court. So it may be the body with clinical responsibilities. I'd expect them to be taking the lead, really. But it also recognises that the local authority has safeguarding. It was part of our safeguarding obligations to P. We think that we need to refer this to the court. And that could be by way of a separate Section 16 application, although I have seen it done in other cases where it's simply drawn in with, as a side issue, almost an application. So I'm hopeful that that's a brief overview of COVID-19 vaccination, which we thought probably needs to be dealt with in a property and affairs and health and welfare seminar that starts with the title, the first thing we need to deal with. But I note when we were asked this presentation that we were also asked to deal with the case of ACC, and that's Property and Affairs Deputyships. So as I say, I apologise that I have no clever segue between my two links, so I plan to just simply move on and deal with an entirely different area, albeit it has arisen under the umbrella that covers us all of COVID-19. So those with health and welfare only practices, hopefully this will be of interest to you. In the background, those less of a health and welfare perspective, hopefully your ears can start pricking up now. So ACC, a big case dealing with deputyships. The background to it was that 3 deputies, 2 of them were trust, 1 an individual deputy, brought proceedings before the Court of Protection, really just to seek guidance on the extent of their powers under a deputyship. And what I will say is it's a lengthy and considered judgment of Senior Judge Hilda. Those who haven't read it, my suggestion would be, first thing, skip to the end, because there is an appendix at the end that summarises the judge's conclusions. Those conclusions are a very helpful little guide for you. What I will say is there has also been, and I haven't referred to it in these slides because I always think it's nice to be able to give people a little bit extra if they actually come along. There is actually some guidance now from the OPG on what they would be expecting to see and guidance following ACC. My plan is to just giving her a presentation, just to sneak the links to that guidance into the chat room for you all to have a look at. But as I say, the judgment is lengthy and considered, so maybe start at the appendix and work back as you need to. An important point that I take up before we go into the principles in terms of ACC is really that reminder that comes stark from Senior Judge Hilda, is that deputyships are the confines of the power of the deputy. So this judgment does nothing to suggest anything further than you have the powers granted to you by the court as a deputy. So you must satisfy yourself, and it is always for the deputy to satisfy themselves that any actions they take are within the confines of the deputyship. Is within the confines of your authority. Can become somewhat make sure that you understand and my advice, and I think one of the points that the court tries to hammer home is, if you don't know, ask the court. That's always the easy way. So try not to take up too much time. What I'll do now is just kind of go things that came out of ACC, and I'll be as quick as I can so I don't eat too much into Keri's time. We can always deal with anything coming out of questions at the end, hopefully. So, as we say, the standard deputyship encompasses common ordinary tasks. We all know this, but what we're dealing with here is to deal with legal tasks. So, authority in the property and affairs deputyship, the standard, encompass ordinary non-contentious legal tasks, including obtaining legal advice, but make sure that you know legal advice as ancillary to the authority. So you can get legal advice under the terms of the deputyship, provided the deputyship provides authority for that specific subject or action. But do note that the guidance in ACC suggests, and I think won't come as a surprise, that specific authority on the behalf of a protected party. The caveats to that are where the litigation is within the court of protection in respect of property and affairs, or to seek directions in relation to a health. Put a pin in that because we'll come back to it because that's really confined. Some specifics there that come out of the guidance. Example, authority to purchase and sell property includes conveyancing, as you might think. Authority to let property includes dealing with leases and tenancies. Authority to conduct businesses including employment contracts. Now, those are of course going to likely be the deputyship, but they link to those potentially actions. And the court might encompass the general authority to deal with property and affairs. And that includes things like along the lines of getting advice on tax returns, getting advice on financial responsibilities under tenancies, and applying funds to ensure that the cost of care arrangements are met, so which may include dealing with employment contracts directly, or indeed using the funds of P. Whether the deputy has authority to make specific decisions to do specific acts in relation to property and affairs, as I said, that adventures litigation. So that's the important thing. I think it's if you're looking for when you need to get relating to kind of up to the point of receiving the letter of response. So that's so the court is able to, and you are able to, as deputy, satisfy yourself really as to kind of prospects of success in the litigation as it were. That again, some other examples, but because of time, I'm not going to go into those in too greater detail. I think the important point, certainly from my perspective anyway, was to suggest that where in contemplation of litigation, that includes obtaining counsel's opinion. It's an important point, but what I will say in the judgment, it's a bit wider than that. What you need to do is satisfy yourself as to the prospects. It might well be that it's disproportionate to get counsel's opinion, but what you can do is make sure you have success, and that can include getting counsel's opinion. As I say, it doesn't encompass seeking advice on steps preliminary to litigation in respect of welfare issues. The reasoning behind the court for that was in effect that it's a property and affairs deputyship. So whilst it's quite proper for property and affairs matters to be brought to the court of protection within the confines of the deputyships and the deputy's authority, it's from welfare. So that means that you would need specific authority to be able to bring those matters to the court of protection, but there is authority to bring appropriate pointing specific authority. So what the court really contemplates here is where there's kind of an overlap really between the duties of the property and affairs deputy and the health and welfare obligations, presumably of public bodies or other third parties. So what the court really said, to make sure the court of protection is dealing with this issue, to make sure you can effectively do your job, first thing you should do, of course, is bring it to the attention of the appropriate authorities. So if it's a deprivation of liberty matter where the funds of P are going to be relevant to where P resides and receives care, then it may be that you need to speak to the local authority and think about whether they need to be bringing in. The court recognises that should, but we don't live in a and if that's the case, then that is the court of protection, and you make it, and then let the court take over in effect. Moving on then, so what I will say is, again, general authority doesn't deal with education, and that's a specific matter, so I should say an appeal against it. The same comes out of challenging continuing healthcare decisions, and that later on as well. So litigation is kind of, I suppose, slightly broadly drawn in those regards, because I think it could be argued, couldn't it? It is challenging a just require action to be taken urgently, and I know this is an important point to a lot of people. Be aware that you may need to start taking actions without the court's specific authority, and you may need to make a retrospective application to cover your funds. Now, the court will hypothetically upon such applications, but the court, so there's no presumption it's going to be granted. You would hope that it would be, I think, in majority of cases, but each application is going to be considered on its merits. I think an important point to think about there as well is depending on the urgency of the case and quite how detrimental it would be to P if we didn't have such authorizations in place. There is suggestion within the judgment that in some circumstances it might be appropriate to ask for urgent consideration of such orders. But in cases, you make your application retrospectively and hope at the central registry, and hopefully it will be dealt with as soon as possible. There is some guidance that I'll also put all about the from STEP, and they deal with this a little bit and suggest, you know, what you need to be doing is just making these applications under the stream 1, COP 1A, COP 24, and hopefully the court will deal with them expeditiously. And coming into the final points that come out of ATC, an important point, I think, and indeed I'm sure key to a lot of people, is how we deal with conflicts of potential conflicts of interests. You know, what are we going to do when a deputy wants to instruct their own firm legal tasks? So there's, in effect, the court kind of really looks at two potential options. One, and an attractive one, I think, is if you are aware that this is going to need to be something to be done as a prospective deputy, try and get it into the initial deputyship and justify the position to instruct both solicitors to deal with the matter, but also point out why it's in the best interest for persons within your own firm to do it. So if you can get it in the original deputyship, that's got to be the preferable way of doing it. The court's always going to look at it and make sure that the court is content that the conflict of interest is properly managed by cost caps or time limiting or something along those lines. But it's the best way of dealing with it, I think, and that's what the court anticipates. But if you find yourself in a situation where something has come up later, you may well need to apply for specific authority. And indeed, some guidance is given there at 9 in the presentation. So what I think you'll be likely to be doing is seeking authority if it is something over £2,000, and I suspect in a lot of cases it's going to be in reality. When you're making your application to the Court of Protection for that authority, the suggestion is you're going to need 3 quotations, and then determine as deputy first which firm is in P's best interests to instruct. Then make your application justifying that position, and then the court will look at it and fingers crossed agree with you and give the relevant authority. So there's effectively 2 ways of doing it. My guidance is if you can anticipate in advance and justify it, get it in the original deputyship, it's just much easier. But if not, there are, I'm afraid, a few hoops to jump through. And when you see the OPG's guidance, you'll see that they obviously have this on their radar, and they'll be expecting these applications to be justified in the annual. And just the final few points, specific authority is going to be required to use P's funds to pay third parties' legal costs, even if the costs relate to litigation. On litigation friends, always do note the official solicitor can act as a litigation friend without charge. So often I think it's suggested that that's going to likely be an appropriate way forward rather than the deputy acting as a litigation friend. Not to say it can never happen, just likely that way. And finally, always a key point to note, so it's so strange almost that it comes at the end, if P has capacity, the issues don't arise. If P has capacity to give you instructions for particular work, then fine, that's your authority. And I'm terribly sorry, Keri, I've got a lot over time, I think, but there we go. I'm hopeful that's been useful to you all, and hopefully we'll have some time for questions at the end. And whilst Keri's speaking, I'll pop those links to the OPG guidance and the step guidance in the chat.
Thanks very much, David. Right, you might all have to bear with me for a minute whilst I deal with this technology issue. I'm hoping to be able to share my screen. And if somebody will nod at me, if this is right. Afternoon, everybody. First of all, I've just noticed that I've completely got the wrong date on these slides. I obviously decided that yesterday was the date we were all going to meet. The second thing is to say that David's right in terms of vaccinations now being heard in tiers 1 and 2. I've got a vaccination case next week before District Judge Ellington at First Avenue House. So certainly after the initial excitement and guidance from the tier 3 judges, I think we're now largely dealing with these as not routine, because they're obviously very important to P, these issues, but as matters which can now be dealt with at that level. Couple of words about me by way of introduction. I think I'm barrister at No. 5 Chambers. I joined No. 5 Chambers about 4 years ago. Spent a lot of my career working in local government, doing children and education work and judicial review. So my practice and my background are broad public and admin law. I now almost exclusively deal with health and welfare cases in the Court of Protection, but also cases that sort of veer off that, either property and affairs matters, education matters, or family matters, sometimes female genital mutilation. That's a little bit about me. I've been asked to cover today where we're at in relation to sexual relations in the Court of Protection, and I've just had a look at how the Court of Protection and the courts generally are looking at coercion and control. They're both areas which are potentially going to be subject to some change. So I'm going to set out briefly where we're at the moment and hopefully give you some pointers on things to look out for as the case law develops. If we first of all, see if this works. Right, hang on. Sexual relations in the Court of Protection and where are we now? Two cases I want to look at. We were asked specifically to deal with a local authority in C, which is the facilitation of contact with sex workers for P. And very briefly, JB, which is the Court of Appeal case, which was heard last year, relating to the test for capacity for sexual relations and the issues before the Supreme Court. Dealing first of all with DY, this was a case that was before Mrs. Justice Knowles earlier this year. The judgment is a 2021 one. And the question is, how does the court deal with somebody who may have fluctuating capacity to make decisions about sexual relations if that capacity is going to fluctuate? In this case, DY, who was P in the case, had just turned 18. She had been assessed as having capacity to make decisions about sexual relations, but lacked capacity to conduct the proceedings and make decisions about care and contact. And those of us who practice in the Court of Protection are frequently scratching our heads when trying to separate out decisions about sexual relations and decisions about contact, because by its very nature, you need to have contact with somebody to have sexual relations with them. And in this case, what the local authority was saying to the court was that although DY had capacity to make decisions about sexual relations, and that was set out in the evidence of Dr. Camden Smith, her particular diagnoses and difficulties meant that if she was under stress or somehow distressed, then she may lose that capacity to make that decision in that moment. And the court had to grapple with how it was going to deal with that. And on behalf of DY, the official solicitor said that she had capacity to make the decisions, that Dr. Camden Smith had set the bar too high in relation to DY's understanding of the relationship between consenting to sexual relations within and outside of a relationship. Mrs. Justice Knowles recorded in the judgment that DY's views of sexual relations were that it wasn't a particularly special or specific act, and she had a pragmatic and unemotional view of sex that could be something quite transactional rather than something intimate, and that was taken, it was thought, from her experiences when she was growing out. And Mrs. Justice Knowles accepted that there was a real tension between a desire to protect DY and a decision that would permit her freedom to engage in sexual relations that might place her at risk, and the need to protect her from other persons, not the person she was in a relationship with, but from other persons who may seek to take advantage of that. Of course, what Mrs. Justice Knowles was constrained by is the fact that, as the law stands, capacity to decide to engage in sexual relations is in a general and non-specific way. So the fact that DY was in a relationship was irrelevant and wasn't planning to have sexual relations with anyone other than her partner was irrelevant to the test for sexual relations. And the local authority, in its written submissions, couldn't really, one of the main difficulties was the local authority couldn't really set out at what point it considered or was inviting the court to find that DY would lack capacity and would lose capacity. And as far as it could go, it said that maybe it would be when she was upset, unsettled or distressed, and those three words were the ones that were used in their submissions. And the judge said, well, that really wasn't good enough. She was being asked to make an order that would prevent DY from having sexual relations with another person. It was going to have to be far more specific and far less objective, because the courts have to be very careful if they're going to make prospective declarations of incapacity, that it's very clear to those who might need to take steps to make sure that P didn't make decisions they didn't have capacity to make. We're very clear about what that was. And the judge said that she had heard no evidence that would support an order in the terms sought. She said at its highest, the local authority is concerned that DY may lack capacity to make decisions when unsettled or distressed was based on speculation about how she would respond in circumstances which may not arise if care and contact were managed separately. And that takes me back to the tension which I mentioned at the beginning, which is that it's very difficult to separate out in these cases capacity for contact and capacity for sexual relations. The question is really, given that the judge was saying that she didn't have the right information, is whether in fact all of this could have been dealt with in a care plan, so that given that DY was not at present at risk of entering into a situation where she may become distressed because she was in a settled relationship and there were no concerns about her engaging in sexual relations within the context of that relationship, whether in fact the local authority might better have managed it by way of having a care plan review if that relationship came to an end, so that they could look at DY's contact with other people in the context of her potentially wanting to engage in sexual relations with them, rather than trying to grapple with that issue ahead of any problem actually having arisen. And of course there is case law to say that the courts shouldn't make orders or declarations in any event if an issue doesn't actually need to be determined, because the whole ethos of the Court of Protection is the least interventionist principle, and if orders aren't required, then orders should not be made. So that is a brief outline of what happened in DY and fluctuating capacity, because the Court of Protection initially was quite reluctant to engage in fluctuating capacity issues. It has become more willing to do so in some particularly controversial cases recently, often relating to gynecological interventions and obstetric interventions in relation to women with particular mental health difficulties. And quite often I've seen a couple of judgments recently where there's a postscript to the judgment to say that in fact P had given birth without the need of the intervention which the court had authorized. So there is a real issue with this fluctuating capacity, and it's something that you may just want to keep an eye on to see what happens, because if these orders and declarations turn out more often than not to be necessary, the court may start to draw back from that willingness to grapple with the potential for fluctuating capacity. The next case I want to deal with is one that we were specifically invited to deal with, which is a local authority in C, which is the case last year about facilitating contact with sex workers. The question was submitted in advance, and just so that set this in context, this is listed for appeal on the 29th of July. So in a couple of weeks' time, this case will be before the Court of Appeal. But this, as an outline, is a case where Mr. Justice Hayden had to consider the situation of a man who had capacity to engage in sexual relations and decide to have contact with a sex worker, but he didn't have the capacity to make the decisions as to his care and treatment or to manage his property and affairs. And a side issue in this actually is that maybe of interest to those of you who do property and affairs work and who do deputyship work who are here today, is that on behalf of C, the litigation friend obtained evidence from the panel of deputies. It was done sensitively and anonymously, but a couple of key headlines from that, that is that their members did have experience of clients seeking sexual services. They were most commonly requested by male clients in their mid to late 20s who'd experienced a brain injury. The deputies had noted that those services had proved beneficial for clients and their support teams. And the concerns were raised, and I think this is potentially the nub of it really, is that concerns were raised that if support to access services was unlawful or inappropriate, the fear was the client may seek to obtain services for themselves, may use social media to do that, and concerns then about them coming into contact with unscrupulous people then who may seek to take advantage of their vulnerabilities. The issues before the court were whether a plan to facilitate the contact could be implemented without committing an offence under the Sexual Offences Act. If not, whether the Act could be read compatibly with the European Convention on Human Rights, or whether the court should make a declaration of incompatibility. And then if a care plan was lawful, whether a care plan would in this particular case be in C's best interests. Very conscious of the time, and I'm not going to go through the judgment in any detail, but the nub of it is really is in paragraph 93 of the judgment, where Mr. Justice Hayden says the mischief of section 39 of the Sexual Offences Act is the exploitation of the vulnerable. He says the provision is perhaps not drafted with pellucid clarity, but its objectives are identifiable. It is intended to signal unambiguous disapprobation of people employed in caring roles who cause or incite sexual activity by people for whom they are responsible. And he says, in my judgment, the expanded interpretation of the provision contended for on behalf of the Secretary of State requires the language to be distorted and the philosophy of the Mental Capacity Act to be disregarded. On that basis, he found that it would not be a criminal offence. He therefore didn't need to go on to make a decision about incompatibility with the Human Rights Act. What he didn't do, he didn't have a care plan before him and didn't go on to make best interest decisions. On the same day, and directly beneath it on Bailey, if any of you want to go to it, is then a judgment that deals with an application for permission to appeal. Mr. Justice Hayden was reluctant to grant that permission, but it was in fact granted. And as I've just said, it's before the Court of Appeal on the 29th of July. Having spoken to counsel involved, they're not sure when judgment will be given. I think they're hoping for it quite soon because best interest decisions have not yet been made. The next slide, and again, this next topic, likely to be relevant potentially also to those dealing with health and property and affairs matters and deputies. And this is coercion and control in the Court of Protection. Two judgments that I just want to touch on in relation to that. There's the case of LW, which was before Mr. Justice Hayden, again in the Court of Protection. We've got the reference to the judgment there. And he sets out in this judgment, it was a 60-year-old woman who'd been admitted to a unit, specialist mental health unit, in a what he describes as truly parlous conditions, and had been in a relationship where she had been, the allegation was at least that she'd been abused. And what Mr. Justice Hayden sets out very helpfully in that judgment is the guidance that's been issued pursuant to Section 77 of the Serious Crime Act 2015 about the types of behaviours and conduct that may amount to coercion and control. And they can be isolating a person from their friends and family, depriving them of their basic needs, and it can include financial abuse, such as only allowing a person a punitive allowance or limiting access to their funds. So if you do have a case where you think that there is an imbalance in the relationship, I would suggest going to that judgment for some guidance to see whether or not that conduct may amount to coercion and control, because it may then assist, and when we look at HN now, it may help assist to frame that application, to frame those proceedings in that particular way. HN is a Court of Appeal judgment. It's a family judgment, but as with a lot of Court of Protection and family matters, there can be some very helpful and significant overlaps. And HN was an appeal to the Court of Appeal. It was four cases, 4 appeals, and to look at the use of finding of fact case hearings in cases of domestic abuse where coercion and control had featured. And the 4 main issues were whether there should be a fact-finding hearing in those circumstances, what the use of Scott schedules, so those are schedules setting out the findings that are being sought in private law proceedings, that doesn't really apply to the Court of Protection. How the court should approach controlling and coercive behaviour, and the relevance of criminal law concepts in private family law proceedings. I'm not going to talk about this at length. What I will highlight is that the court said that there's a practice direction 12J, which is used in the family courts, said, well, that continues to be relevant and it continues to be sufficiently robust for present purposes. And certainly I've had cases in the Court of Protection that have very much a domestic violence theme to them, where P has recently become an adult but remains living with one of the parents, and that the difficulties in that relationship persist. And the judge in my case there, in fact, very helpfully deployed Practice Direction 12J and used it as a framework for making decisions in the Court of Protection. So again, it's a useful case for pointing us towards that helpful practice direction. And what HN says is have a very careful think about whether in a coercive and controlling environment it is appropriate for a Scott schedule and a finding of fact hearing, because these types of allegations can be much more nuanced and much more subtle than, for example, on this particular day, this particular person banged the door down or caused a particular injury. But the other caution, main caution in this case, is that when family judges and Court of Protection judges, by analogy, are dealing with these cases, if there is an allegation that may in other jurisdictions amount to a criminal offence, that is not the test to be applied in these cases, and that the court needs to look at, in fact, what happened rather than trying to apply any particular test to it, and the impact of that behaviour on the relationship and the issues in the case, rather than having too much of a focus on whether offences have been committed. So that was just to highlight a couple of cases that may be helpful in dealing with those types of cases. Very briefly, liberty protection safeguards, where are we now? I'm going to say very little about this because I think we've all spent a lot of time talking about this and still nothing happens. Currently, implementation is set for April of next year. I've given you that an email address if you want to subscribe to the implementation newsletters. Those will then give you links to the LPS document collection, which is on the .gov website. There is a draft code in circulation, and there are 9 fact sheets which have got some high-level information. But most importantly of all, just so that you all know, we are planning at number 5 to do a seminar on this in February. So my last slide is we have got this autumn some seminars coming up, a property and affairs seminar, I think in October, and one in November, health and welfare. And we plan to do an LPS seminar in February, by which time hopefully everything will become much clearer. In the meantime, if you want to go on a distribution, and that's me done for now.